The first case we have on the docket is Marion County versus KIRK, and I notice that the appellee has not filed a brief, so cannot participate in oral argument.
Thank you, Your Honor, and may it please the Court. My name is Thomas McNamara. I'm Chief Assistant County Attorney for Marion County. I also have with me co-counsel Christine R. Davis from Tallahassee, who represents the property owner in this case. We would like to divide our arguments and would like to request the Court to give me the slow pitches and save your tough questions for Ms. Davis. She's the expert here. We have a writ of mandamus that the Circuit Court issued, and we are asking the Court to reverse that. The facts are fairly simple in this matter. There was a property owner, C&K Investments, that owned a 39.59 acre parcel, which they would like to use for a sand mine. Under the Marion County Code, that requires a special use permit, which the Board of County Commissioners actually granted. One of the property owners, adjoining property owners, is Michelle KIRK. She filed pro se a complaint for writ of mandamus on behalf of 4 undisclosed landowners that did not get notice.
When the motion to dismiss was filed, was it argued that mandamus was not the appropriate remedy here?
Yes, sir, it was. And the argument was that review of quasi-judicial zoning decisions under Florida case law is by petition for writ of certiorari, which was not filed in this.
Was it argued that it would be a futile act to ask for mandamus to require notices of a hearing that had already been held?
That was not in the record, but that is certainly the argument we are presenting to this Court. Especially because...
The primary argument was that mandamus wasn't appropriate because the appropriate remedy was cert?
Yes, sir.
Was there an argument made below as to whether or not the Court could treat the mandamus petition as a cert petition?
The argument was not presented. Certainly the rules do provide the Court that latitude.
Any indication the trial court did that he considered it as anything but a mandamus petition?
No, sir. And the peculiar facts in this situation was that the petition was filed pro se against Marion County, and it was not served on Marion County. And the trial court initially dismissed the petition.
They refiled it, though, didn't they? Did they refile it?
They filed 2 amended petitions through counsel and actually served the county in that process. But it's important because the amended petition was treated by the trial court as reconsideration of his order for dismissal. And that is what the hearing was that we went into, and that was the only hearing before the circuit court.
What difference did that make? Was the ultimate issue whether or not the amended complaint stated the cause of action?
That was an issue raised in the motion to dismiss. And the motion to dismiss was set for hearing. And it was presented to the trial court that there really were 2 issues that we needed to get to even before we reached mandamus. One was reconsideration, because if reconsideration wasn't granted, the petition was dismissed. The second one was the county's motion to dismiss.
Was the petition dismissed with prejudice or without prejudice?
Without prejudice.
So they clearly had a right to amend it, so whether the reconsideration had been denied or not, you would have ultimately had to look at the merits of the third amended complaint, right?
Generally, you can amend with permission of the court, which was never secured in this particular action.
But it was dismissed without prejudice, you said, correct?
It didn't address with prejudice, so...
Doesn't that give you an automatic right to refile?
I think with permission of the court, under the rules. And So when we came to the hearing, the reconsideration was the first issue, the motion to dismiss was the second issue, and the trial court bypassed both of those issues and went right to the second amended complaint and conducted a hearing on mandamus.
The order that Judge Singbush entered says that the petitioner's second amended petition for writ of mandamus is granted. What was going to happen? I mean, the hearing had already been taken place. There were allegations that they weren't properly notified. So I guess I'm trying to figure out, what happened when he granted the writ of mandamus? What was supposed to happen? Just notices sent out or what? I mean, it doesn't say that there's supposed to be another hearing.
It's not clear from the order what was to be done. They were clearly requesting another hearing before the Board of County Commissioners. This was, in effect, their stick that they could beat the county commission with because they didn't like the decision that granted the special use permit for this mining activity.
Well, assuming it was true that they didn't get notice, aren't they entitled to have notice?
Yes, and they.
Well, what's their remedy if the county didn't send out any notices and they conduct a hearing without notice to the people in the community? Isn't the remedy to require it to be redone with notice to the people in the community?
By petition for writ of certiorari.
Why would it be certiorari?
Because certiorari allows you to bring due process before the court. And
there's no challenge here to the merits decision. The challenge is to the procedure. If I'm entitled to notice as a citizen and you don't give me notice, aren't I entitled to mandamus to require you to do it?
The facts on this case, she was given notice not once, but twice.
Trial court found to the contrary.
It did not find to the contrary. It's not in her order. It's the decision of the trial court that the burden was on the county to provide proof that notice to each and every property owner was actually mailed.
Correct. When I file a petition for writ of mandamus and I say you didn't give me notice, then when you go to the hearing, then the county is supposed to show that it did give notice.
Correct.
And in this case, the trial court found that you failed as a matter of proof.
Well, I agree with the courts, but under the rules, the court is supposed to issue an order to show cause if the petition states a prima facie case for relief.
What I've got right here is what happened at the hearing on the petition for writ of mandamus, at which there is no discussion at all of certiorari. You go by the consideration issue, which I'll grant you, and then the trial court says, it seems to me the first amended petition's been set over. We have an opportunity to address the matter on the merits. Why don't we do just that? And you said, we're prepared to do that, Your Honor, and then presented 3 witnesses to testify to prove that you in fact sent notice. Isn't that so?
Yes, that is correct.
And the trial court then found that although you had extensive testimony about the preparation of the area and the list of who was supposed to get notice, and that all of your witnesses testified that it then goes to the taxing department, whatever it's called, for mailing, that there was no evidence offered at all that there was any mailing, either in this case or that there was a practice of mailing by the people charged with doing it. Isn't that also so?
That is correct, Your Honor.
So why is it erroneous for the trial court to have concluded that it was that you failed in your proof that you gave these people notice?
Because actual mailed notice to an individual, when there are hundreds of notices being mailed, is an impossible burden to
all you had to do was bring somebody from the department that mailed these things out and say, either A, we mailed these, or B, it is our practice to mail them when we get them from the other department. That's where the trial court found that your proof failed.
But
what's wrong with that?
because on cross-examination, do you remember the actual letter addressed to Michelle KIRK? Did you actually put that letter in the mail? This is months after hundreds of letters on this just one issue have been placed in the mail. There's no way the mail person memorizes each and every addressee.
Were you able to do it on rehearing, weren't you?
We were able to establish that in the normal course of business, these are mailed by the MSTU department.
Right.
But that testimony was also before the trial court at the hearing, that in the normal course of business, these were prepared. Each and every person was on the list. The notices were prepared by the individuals given testimony, and they were mailed. They were presented to the MSTU department for mailing. And there's a presumption that you follow the normal course of business.
Well, we're not talking about a normal course of business. We're talking here about evidence that they were actually placed in the mail.
Correct. But the evidence involves a presumption of following the normal course of business, which is when you prepare these notices and you bring them to the department for mailing, the department puts the postage on them and mails them. The same thing as the circuit court. The circuit court has one department that puts postage and the postage meter on each and every document that is mailed. If you had the burden of saying, Mr. Postage Meter person, do you remember this notice going to this individual?
That's what the trial judge said. The trial judge said that you proved beautifully the preparation of the document to the point that it got sent to the department that was charged with doing the mailing, but there was no evidence from anybody in the department charged with doing the mailing of either what their normal practice was or that they put these in the mail. And so he found that there was a failure of proof. Isn't that right?
That's correct, yes.
What's wrong with that?
What's wrong with that is that it places the burden on the county to prove that it has done the correct thing. In other words, there was no testimony, there were no witnesses presented by the petitioner in this action. The only evidence, the only testimony was presented by the county that the notices were prepared, that they were all on the list, that they were all sent notice. In rehearing, it was established that the MSTU department mails every notice they receive within 2 hours by putting postage on it and bringing it to the post office. That closed that issue.
Your primary argument is that you established the presumption. It was up to them to present evidence to rebut it.
That's correct, yes.
Hey, can I get back to the mandamus issue? And I would like to specifically address Board of County Commissioners of Brevard County versus Snyder. Are you familiar with that decision?
Yes, sir.
What does that decision basically hold?
That the review of quasi-judicial zoning decisions is by petition for writ of certiorari to the circuit court.
Okay, and if the matter is reviewable by cert, is mandamus an appropriate remedy?
It is not, in my opinion. And there is no case law to
And was
support
that argument made to the trial court?
It was presented in the motion to dismiss that was scheduled for hearing, which was bypassed by the trial court. So the issue was presented to the court ignored that issue.
And when the court decided to go forward on the merits, did you say, Judge, we first got to determine whether mandamus is appropriate. Our argument is mandamus isn't appropriate, so you shouldn't go forward on the merits.
Those issues were all stated in the motion to dismiss.
But did you raise them to the trial judge when the judge decided to move forward on the merits?
It was brought up that the motion to dismiss was scheduled for this hearing, and that should be considered prior to the mandamus petition. So yes, that was.
What did the trial court say about that? I think what the questioning is basically going to whether you waived your argument contained in your motion to dismiss that cert was the appropriate remedy by saying that, yeah, we're prepared and presenting the witnesses and going on with the hearing on the merits. I mean, did you waive? The question is, did you waive your your objections raised in your motion to dismiss that mandamus was not the appropriate remedy, is the ultimate question.
No, there was no waiver of that.
Let me go back to one of Judge Griffin's questions, which I don't think I heard an answer to. Because she asked you, in that circumstance where notice is required to be given and notice isn't given, what's your remedy? And your response was, well, in this case, notice was given, but you never addressed the hypothetical. If no notice is given and there's a mandatory requirement to give notice, why isn't mandamus the appropriate remedy to address the procedural issue of whether or not notice has to be given?
The first answer is that it violates the presumption of notice in the normal course of business, which was presented. Secondly, it violates the Snyder decision that says that review of quasi-judicial zoning decisions is by petition for writ of certiorari.
Was Snyder a review on the merits of the zoning decision, or was it on some procedural issue?
Snyder allows you to bring procedural due process to the circuit court.
Let me ask you a different question. As I understand it, the only person who's a named party here is Michelle KIRK, correct?
That's correct.
So the only issue is whether she got notice. Is that correct? She wasn't representing a class. She couldn't present the interests of anybody but herself, correct?
Correct.
Was there evidence in the record that she had actual notice, even if there was a question about whether the written notice was mailed to her?
Yes, there was.
What was the evidence that she had actual notice?
There was testimony by the zoning director that notice goes to property owners within 300 feet of the property that
I want to know if there was any evidence she specifically knew about it. She came to a hearing, she corresponded with anybody, anything other than what you would get from a presumption of notices going in.
In response to that, the zoning director testified that she received mail notice at her address in Miramar, Florida, and that she then came to the zoning director and said, I'm building a house in Ocala, please send my notices to my father's address, which is an adjoining lot, which already had a house. She had a vacant lot and was building a house, so she didn't have an address. The zoning director testified that address to Michelle KIRK went to her father pursuant to her instructions, so that in effect the testimony before the trial court is that she received notice twice. And she did not testify contrary to that. She did not sign a verified complaint. So the only evidence was that she not only got notice once, she got notice twice. Also, in rehearing, she signed a petition that was presented to the Board of County Commissioners in opposition. I believe she was the second signature on the petition that was presented to the board at the public hearing where they made this decision. Again, actual notice because she was in opposition to it.
Why is that actual notice of the hearing? Maybe she signed a petition but didn't know when it was going to be heard, so she couldn't be there.
That's possible. Also, the record reflects that her brother, who was going to build the house with her, testified at the zoning commission meeting and was aware and testified at the Board of County Commissioners meeting. So her brother was also aware. Now, that doesn't necessarily mean that she was aware, but it suggests that she was leading the opposition to this proposal. And when the decision...
That might be a good argument to the trial court, to try and convince the trial court to find notice. But if it at most suggests a possible notice, that doesn't help us much in reviewing what the trial court decided, right? Because we can't consider that possibility.
But you can consider that there was no evidence to the contrary. There was no evidence that reversed the presumption that she was mailed actual notice by the zoning board.
When does the presumption arise? What do you have to prove for the presumption to arise?
That the procedure was to, and this was before the trial court, that the procedure was that the property was taken to the county GIS system which is a computer-generated map system. It pulls all of the property owners within 300 feet. The testimony was that they actually did 315 feet to make sure that there was nobody that slipped through the crack, and that the computer then generates the addresses of all of these people, and that the addresses were then sent notice. The notices were prepared by the individual that testified. They were prepared, they were put in envelopes, and they were brought to the MSTU department for mailing. So the presumption was that in the normal course of business, notice actually went out to this individual. Now, whether she received that notice is not necessarily the issue.
Well, I don't think the trial judge did it on the basis that you didn't receive it. I think the trial judge did it on the basis that you didn't prove it as the same.
Correct. I agree.
And your time's expired, sir. Thank you.
Thank you, Your Honor.
Now, that was all of your time for both of you expired. That was your full 20 minutes.
Let me ask one more question
Okay.
before you leave, if you don't. I'm curious about the provision in the order that says that nothing herein shall prevent either party from presenting a timely, authorized, and legally sufficient motion for rehearing. Motion for rehearing is authorized by the rules anyway, and I'm curious as to why the judge put that in there when it absolutely wasn't necessary. Do you know why?
I do not know why the trial judge.
Was it anticipated that? It seems to me that it may imply that it was anticipated that you would file a motion for rehearing with affidavits going to the mailing issue, but I'm not sure. I don't know if the record speaks to that or not.
The record doesn't speak directly to that, but I think that can be taken from the record. If you read the trial judge's ruling, he clearly says you didn't show actual mailing, and I will allow a rehearing. And if I could just be permitted to respond to two issues that the court raised.
Wait a minute. He said the trial judge said that you didn't show actual mailing, so I will allow a rehearing to do what?
He just said, he didn't say to do what. He just said, I'll allow rehearing. But if I could have permission to just address two issues that the court raised. First, the trial court's ruling was that actual mailing was required. That is directly contrary to the Florida Supreme Court decision in Brown versus Giffen, as well as this court's decisions that say actual mailing is not required. As long as you show proof of general office practices, it's sufficient. Also,
Part of the general office practice is that mailing is done, right?
Right, and we had testimony that she put it in the mail, that she had prepared the packages, put the postage on it, and gave it to the MSTU. And under the case law, that's sufficient. In the record, she had actual notice because that petition that you referenced, that's at pages 88 and 89 of the record, has a notice on there that says when the hearing was and what time it was going to take place. So if she read the petition, which presumably she did before signing it, then she had notice of that. And finally, mandamus is improper here because mandamus cannot undo a permit. If a person wants notice after a permit has been issued, it has to be through a writ of certiorari because the only thing mandamus can do is provide a ministerial act.
And what's your best case on that?
My best case on that is Migliori, and I'll give you the site. It's 415 Southern 2nd 62. It can only lie to compel a county to perform a ministerial act. It cannot undo a permit. It cannot undo a quasi-judicial discretionary decision of a circuit court. So since the permit had been issued in this case, if you issue a writ of mandamus, it'd be meaningless because you can't undo a permit.
That goes to the line of cases that basically say that once an order is entered, mandamus is not permissible to undo the order. You have to go to cert.
That's right. And when Judge Griffin asked what the remedy would be for notice, it would have to be certiorari where she would attack the procedural due process prong of that because mandamus could not undo a permit. And so if she really wanted notice and if she really wanted to speak in opposition, you'd have to quash that permit first, and that can only be done for certiorari.
How can you require someone to file a petition for writ of certiorari, which has a time deadline, if they are alleging that they didn't get notice?
Well, in this case, she filed it within the time deadline, but the answer to your question is that's what the case law requires. That's the only mechanism to undo a permit.
What about the requirement if someone seeks an improper methodology of review that you treat it to the
I'm glad you asked that question
should be?
Because the heart of this case is whether she got notice. And even if the trial court had treated this as a petition for certiorari, he would have been required to deny it as a matter of law. The petitioner in this case presented no evidence to substantiate her claim that she got notice. She didn't submit a verified petition. She didn't submit an affidavit, and she never testified that she had notice. There's absolutely no evidence in this record to substantiate her claim. So regardless of any way you treat it, if you treat it as certiorari or mandamus, it would have had to been denied because she didn't prove her claim. She put
There was no objection to the proceeding at the hearing. I mean, I've read the hearing transcript. The assertion was made that she didn't get notice, and then the county proceeded to try and prove that they had sent notice.
That's right, but there's no evidence.
I mean, there was nobody ever raised their hand and said, hey, she hadn't proved that she didn't get notice here.
That's correct, Your Honor. But considering the record,
We had an extensive hearing here based on whether the county had actually mailed it.
right. But if you look at the record,
Can't
there's
raise
no
something that the
evidence.
trial judge, it was never brought to the trial judge's attention that there was a failure of proof.
That's right, Your Honor. But it was shown that the general office practices were followed. That's what the case law requires, which doesn't require actual mailing, and there's absolutely no evidence to the contrary.
Did I understand you to say that the petition that contained her signature was a petition that listed the time and the place
That's right.
of the hearing?
If you look at
What was is that correct?
That's correct.
What was the evidence that she had signed the petition?
Well, we have the petition in there with her signature on
I
it. and her
understand. Was
address.
that authenticated? Did she admit that was her signature, or is there just her name there that somebody signed
It's her name and her address.
and nobody authenticated it?
Well, there's an affidavit in the motion for rehearing that authenticates the petition, but you're right, nothing to authenticate.
Okay, you're well over your time. Thank
Thank
you.
you.